know how guardianship works in New York? If a person doesn't have a very comprehensive power of attorney and something happens to that person where they can no longer take care of their financial matters or their property by themselves, and the prime example of this is someone has a serious stroke or has an accident and they need a rehab or a nursing home, it is going to be necessary to do some serious emergency Medicaid planning to protect their assets so the assets don't get drained to pay the nursing home. Do you know how guardianship works if you don't have that power of attorney? The way guardianship works in New York is we have to, first of all, the family has to hire an attorney, and a petition has to be made and filed with the court requesting the appointment of a guardian for the incapacitated person. The first thing the court will do is appoint a court evaluator and possibly court-appointed counsel to represent the incapacitated person. Then the court will schedule a hearing date. In between that time and the hearing, the court evaluator and or court-appointed counsel will go out and see the incapacitated person and assess the situation, speak to the family members, speak to the potential guardian, and then a hearing will happen, at which time the guardian is going to testify, the court evaluator is going to testify, the court-appointed attorney is going to represent what that person believes to be the interests of the incapacitated person, and then the court will typically make a ruling from the bench. What happens next is the attorney for the petitioner is going to get the transcript of the hearing, prepare an order and judgment for the judge to sign. The judge will typically require a bond, so the proposed guardian will need to get a bond in place. Then the guardian's going to have the attorney prepare a commission to guardian, an oath, a designation, consent, and then once those are all signed, which is going to be a few months down the road typically, then the guardian, the newly appointed guardian, is going to typically have to go back into court and ask the court for permission to transfer assets out of the person's name. Now, in the meantime, this person has been in the rehab or the nursing home for, let's say, 3 months before anyone could do anything with their assets to protect them. So very possibly you will have 3 months of $18,000 a month nursing home bills racked up already that have to be paid for privately. Once the court gives permission to take assets out of the person's name, then the guardian can do so and will be reporting back to the court every year by doing an accounting and showing the court everything that they have done for that person's benefit. You will be under the court's direction for the rest of the guardianship. The fees of the court-appointed attorney and the court evaluator will be paid out of the incapacitated person's funds, and anything special that needs to be done for that person, anything that needs to be purchased for that person, other than everyday things, the guardian is going to have to make an application to the court and get court permission. The fees for all of this will be they'll be over $10,000. They might be under $20,000. They might not. It's a time-consuming, difficult, expensive process. And the way to avoid that process is by having a proper power of attorney in place in the first place, and a healthcare proxy, so that you've already appointed somebody to take care of your business if something happens to you, to make healthcare decisions for you if something happens to you, and you can't do these things on your own. That's a several $100 proposition. So most people don't know this. They don't understand that the guardianship system that we have in New York is not cheap, it's not easy, it's not pleasant, and it is to be avoided if at all possible.